taking the time. I know everybody's busy with things that you have going on, so I want to thank everybody for taking the time to come. Especially want to thank Pat and Randy for taking the time to come and speak to you guys. My name is Eric, and Mariah is sitting in front of me. We are co-chairs of the Bucks County Down Syndrome Interest Group. So we're presenting this tonight for you guys, so thank you very much for coming. I want to apologize. I know in the emails that I had sent out and kind of the evites and things, I had said to go through door 5. I found out when I was here that door 5 was locked, and we had to come through door 1, so I was standing outside kind of directing people in here. So I apologize for if you drove around a little bit. I take full responsibility for that. Again, I'm sorry. So with that, we do have water over there. If anybody wants any water, you're more than welcome to grab some bottled water. We have paper and pens on the tables for you guys to take notes, although I see most of you guys brought notepads and pens yourselves, so that's great. So again, feel free to the water. If anybody needs to use the facilities, they're straight out that door right beyond this wall there on your right-hand side. And with that, I'm going to turn it over to Pat.
And we are videotaping, so if you know of somebody who can also have benefited from this, we're going to videotape it. We're going to put it on a private YouTube address. We'll send it to everyone that was here. You can send it, then send it to anybody, a parent, a social worker, whatever that you feel could benefit from it. And that'll come. Make sure you sign up on the sign-in sheet, and we'll make sure that gets to you.
Am I in frame here too? Because I know I'm going to move out of frame once or twice.
Are you? Yeah, you're good. You're in frame.
All right, so I got to stay.
Yeah, just right there.
Thank you guys. Thanks Mariah. Thanks Eric for having us come in and speak to you tonight. I appreciate you all taking time out of your busy schedules and braving the weather to come out and listen to Randy and I for a couple hours and really try to digest this important information that we're going to talk about tonight. But I like to get started with these things by doing just a quick bit of housekeeping, talk about the information that you see in front of you. And if you have not received all of this, there's a table in the back, and my partner Isidore can give you a copy of anything that you need from. But it's funny, dating back into 2000, it was either 2009 or 2010, first ever special needs planning workshop I did was for the Bucks County Down Syndrome Interest Group, and it's nice to be back here. I see some familiar faces, some that were actually at that first presentation, which is interesting. So hopefully you can critique me on how things have changed over 5 years. But what you see in front of you, you'll see a couple pieces of information that are pretty basic. They have our contact information on it. First is Randy's contact information in her bio. There's a piece with my updated contact information on it, and if anybody has seen us present before, or specifically seen me or received my emails, you'll notice our contact information has changed. It was 2.5 weeks ago, Isidore, myself, and our other partners actually transitioned firms, so you're going to see a lot of information that's still branded with the MetLife Center for Special Needs Planning, who I still keep a close relationship with, until we get everything transitioned over to the new firm. But a couple things that'll help you as takeaways for this. There's these 10 basic steps. Think of it as a summary of some of the key things that we're going to talk about tonight that's on here. When you are a caregiver of somebody with special needs. Has anybody not heard of the Special Needs Alliance before? There's an example of one of their newsletters. This is an organization that sends out this, I think it's a monthly newsletter. They have a great archive on their website. Their newsletter is free. All you literally have to do is go to their website and it's enter your name and your email address, and you can get signed up for their ongoing newsletters. It's a great resource just to get additional information. I'll talk about the agenda, but at the end, we're going to wrap tonight with a brief, high-level overview of this new ABLE Act. This is kind of a Cliff Notes version of that, just a summary of the key points of that act and the accounts that that act will create. And then lastly, probably the most important part of this presentation is this evaluation form. This gives us a chance to let us know how we're doing, topics of interest that you might want to include for a future presentation. But we're going to talk about a lot. We're going to go into detail on certain things, but we're not going to go into detail on every aspect of special needs planning. So if there's additional information you would like some follow-up, contact about, or if you have additional questions, myself, Randy, or Isidore will be able to pick this evaluation form up before you guys get out of here. So I hear we have this till 9 o'clock, so hopefully everybody has some coffee beforehand. We are not going to speak until 9 o'clock. Just a quick overview of our agenda, what we're going to present on. I'm going to give first an overview of government benefits, talk about the world of entitlements versus the world of eligibility-based benefits. Randy's going to come on and talk about the important legal side of this planning, the documentation that you should be considering, choices between guardianship and power of attorney when your loved ones turn certain ages. I'll come back on to talk about some of the financial planning aspects, how financial planning with special needs is quite different than traditional financial planning. And then we'll wrap with the ABLE Act, and then plenty of time for question and answers either as a group or one-on-one, or if you want to come up to any of the three of us with your questions. So, just by a quick show of hands, who has seen Randy or I present before? A couple of you, okay. So for the newcomers, thank you. And just to know who's in our audience today, because there's different stages of special needs planning that we'll talk about. Who in here has a loved one between the ages of birth and 5 years old? Okay, 5 to 14? 14 to 18? 18 to 21? Any 22-year-olds out there? Okay. Then,
we have one. We have older too.
Yeah. So then the next range is 23 to now 26, and then above 26. So some of those ages were extremely important, and we'll talk about that and why some of those ages are important, some more recently than others, and how it might pertain to you with planning for your loved one with special needs. So our objective is to share with you as much as this information. It's not to make you experts in special needs planning. We can't do that in an hour and a half, 2 hours tonight with you. But it's really to share with you some of the common planning mistakes that we see, share with you some of the strategies to avoid those pitfalls, and hopefully, if anything, to motivate you to take an active role in your planning, to know that there's going to be a point where relying on the government, relying on school districts, that's not going to be there anymore. It's going to fall on your shoulders. And that with proactive planning, with you taking a lead in this, it's going to open up opportunities for lifetime care and quality of life for your loved one with special needs. And that, I would imagine, is why everybody is here tonight. So I'm going to jump around through this. I've tweaked this. Fortunately, with the transition, I've been able to make this presentation my own now. But when you think of the statistics, and I think this overstates statistics greatly, because I've been doing financial planning for 9.5 years, for the past 5, focusing on special needs planning. I've yet to sit down with one person that has had every single aspect of this planning done, and done as efficiently as possible. So I don't think 21% have done enough. But if you find yourself in that other percentage, don't worry. Just realize you're not alone in this. You're all here, which means you have an opportunity to do this planning. That's the good thing. But really, just know that there's no perfect time to start this. You're going to get bombarded with information tonight. You're going to be your head's going to be spinning, wondering, where do I start? And most people that come to these workshops, they fall into one of two camps. It's those that haven't done anything yet, which is okay. That means there's nothing that needs to be fixed and redone. And then there's those that have done something, a level of planning, and they're coming for a refresher to make sure that we've done it and we've done it right. So feel free to interrupt during this if you have questions. We do try to save them for afterwards. That way the presentation isn't dominated by all questions, so we can get through all this information. But I'm a big fan of audience participation. So if anything is confusing or if you need any kind of clarification, please stop me. So this quiz here, if you read these questions to yourself, think about how your answer right now might be affecting your current planning situation. So I apologize if you didn't get a chance to read all 3 of them, but we will come back to them. We'll come back to them in detail. But if you did say yes to any of those, what that does mean is there's some planning that you might need to consider. So when Randy will get on and talk about the legal side of this, and I talk about the financial, we want to make sure you realize that this is very different than your traditional financial and estate planning. When you have a loved one with special needs, it is critical that you work with the right team of advisors. And most importantly, I believe, from a legal standpoint, because there's plenty of attorneys out there that will say that they can do this type of planning, but they shouldn't be. And before I talk about attorneys too disparagingly, is anybody in here an attorney? No? Married to an attorney? All right, good. So how I've explained special needs planning and what really goes into a comprehensive special needs plan, there's 3 main areas. The first area is where most people will gravitate to with this, is the legal side, which is where you work with an attorney to draft specific legal documentation. And that attorney needs to be somebody doing special needs estate planning all of the time. That is their focal point of their practice, something that they are passionate about and typically emotionally involved with as well. I've used this analogy with the show Lost, if anybody watched it. The main character was a guy named Jack, and he was a spinal surgeon. So think of it this way, if you go to your primary doctor and you get diagnosed with a spinal tumor, you're not going to have your primary doctor remove it, right? You're going to go to a specialist, somebody that does this all the time so you can safely walk out of the hospital. This is how you should approach your legal planning. There are a handful of attorneys just in this 5-county area that truly are experts in this area that have the proper tax planning background too. So it's one of the first things that I'll look for is which attorney might have done any documents that have been drafted. So the legal side is creating framework. It's framework for assets to be received in a way they won't jeopardize benefits. It's to structure other assets that will go to your other loved ones in a way that they're protected. And it's to make sure that decisions that are made at certain ages for your loved one is that you're educated on all the different options that are available to you, and no one's pushing you in any one direction. The problem with special needs planning is has anybody found the manual yet where you went to the IU or the county and said, where's the manual for having somebody with special needs? They haven't made one. And it's actually not a bad thing because there is no cookie cutter approach to this. There's no one size fits all. There's no my loved one received the benefit, which means everybody else should receive that same benefit. It unfortunately doesn't work that way. And things are confusing. Navigating government benefits are confusing. The legal side, financial, it's all confusing. But the benefit is people in this room, look at them as your opportunity not to have to go out there and reinvent the wheel. What I found is this Down syndrome interest group is one of the more active that I've seen, and you're able to tap into resources of parents that have gone through things that you're now embarking upon, that potentially learn from mistakes, or not to call them mistakes, but learn how to do things maybe differently where you avoid some of the headaches that other families had to deal with. So it's a great way to tap into some of these additional resources that are here. The second leg, or the second area of planning that ties right into the legal side is what we do, which is the financial side of this. Our job in special needs planning is to do everything that, say, a typical planning situation would involve, savings, managing debt, paying for college, retiring someday, making sure we all have the right insurance, leaving money behind and doing it in the most tax efficient way possible. Special needs takes us to a whole different level because we're planning for what could be 2 lifetimes in this. Somebody that's going to be beyond us for a pretty good chance. And if we're going to be leaving assets behind, we need to talk about taxes. Uncle Sam does not care if we leave assets to a loved one with special needs. He does not tax them more favorably. So we need to be cognizant of that. How we invest, what we invest in, the type of accounts we invest in, that's all different with special needs because we have to be mindful of taxes. What types of insurance and how much you get it, it's all just a different vantage point from looking at things. So our job is to make sure this legal document that you create with an attorney like Randy eventually gets enough inside of it, which could be while you're alive, it could be from other family members, or it could be when you pass away. Regardless, we just want to make sure enough goes in there to provide lifetime care and quality of life. And then the last side of this, which in my opinion is the most confusing, is the legal and government, or the government benefits side of this. How do we navigate them? How do we maximize government benefits? Who's there to continue doing this for us when we're no longer around or no longer able to? So with government benefits, which eventually leads into care management or care planning, yes, there's individuals from the county that can help to a certain extent. There are individuals that for a nominal fee can help you navigate this system because it's confusing. If you get denied a benefit, you don't even know where to start. Like I said, this could save a lot of trouble and a lot of frustration. But the government benefits and the care management brings the emotion to this, which is you're gone, money's in this legal document, now what? Who is going to replace you? Who's going to make sure that money is actually going to be used the way you want it to be used? If there's $100,000 or $2 million in this legal document, you want to make sure it actually does get spent the way you would have intended it to be spent. It just doesn't sit there for the rest of your loved one's life, that it is going to be spent to enrich their life. It's going to give them a better living situation. All the things that you are currently doing as the primary caregiver. So skipping through this, we'll come back. Of course, I'm going to pause on this slide. So my teachers, back when I was in school a long time ago, always made it a point to say, if you're going to write anything down, this next point is going to be on the test. So there's no test at the end of this, but this next slide, if you take anything away from tonight, is probably one of the most important things. So have you left over $2,000 to your loved one with special needs via your will or via a plain vanilla trust? So federal law says if you leave over $2,000 to a loved one with special needs, he or she will automatically lose eligibility for most government benefits. So is that the first time anybody's ever saw that dollar amount before, $2,000? Yeah, there's always a couple, and when you first hear that, it's pretty shocking because the point of this is lifetime care, and how can we do that without being able to leave over $2,000? That's the point of this planning, which is going to come up with some strategies that we can do this. So before Randy shares with you the strategy to allow this, let's talk about benefits, because they are confusing. If you want to, carve benefits into two. There is the world of entitlement benefits, and then there's the world of eligibility-based benefits. So we'll start with the eligibility-based benefits. For those of you that have a loved one that is in school under 21 or under 18, everybody should have them on Medicaid. Medical access, medical assistance, MA, whatever you would like to call it. So medical access, medical assistance is health care. Pennsylvania is a unique state. Medicaid eligibility is guaranteed for individuals under 18, regardless of what the parents make and regardless of what the parents have in assets. All of the surrounding states, it is a financially tested benefit. So unless the parents are at, say, a poverty level, a minor under 18 would not be eligible for Medicaid. But in our state, there's this loophole, but it's also the only way to get wraparound services in school. So it's a very important benefit that everybody should be on, even if you're not using it. I've had families come back and say, well, we don't need this. There's other families that need this more than us. I can understand where they're coming from with that, but at the same time, you want your child in the system. You want them in the system as early as possible. God forbid something changes in your lifestyle that, don't worry, nothing yet of crux that you've missed, so it's okay. So the $2,000 in the entitlement world, or in the eligibility-based world, first is Medicaid, which is health care. Then there's this benefit called SSI. SSI is it's very often confused with a Social Security benefit, which it is not. SSI is supplemental security income. It is a monthly cash benefit that is intended to pay for the food, the shelter, and utility bills of our loved ones with special needs. When you have somebody under 18, they base that eligibility off the parents' income and assets. So it's the same test that's Medicaid, but there's no loophole for SSI. So if you've applied for SSI and you have a minor and you got denied, it's because you were financially ineligible for it. That all changes when they turn 18. On your loved one's 18th birthday, the government no longer cares what the caregivers make or what they have in assets. It's based on what that individual has in resources and what they have in income. Now, because we're speaking for a Down syndrome group, Down syndrome is a very unique diagnosis that regardless of IQ or functioning ability at 18, be it by diagnosis specifically, you are always considered disabled under the definition of disability under Social Security.
There are a few other diagnoses here,
Okay.
right? Yeah,
So
I
I'll
know
point
there's a
that.
couple.
So
Yeah.
Down syndrome has that automatic, you're still disabled as an adult. Autism doesn't. Just because you have an intellectual disability does not mean you have to. So at 18, there's this testing you need to go through. So you have to be requalified as an adult, which is you cannot have substantial gainful activity, which is roughly earning an income above $1,000 a month. You have to have a significant cognitive or physical impairment that has lasted longer than a year and is expected to last another 12 months. So it's a tough test. There's not just because you have autism. Higher functioning with Asperger's, lower functioning or moderate functioning, there is no one way that this is going to go. And what we encourage is when you have to apply for this SSI, and there is a face-to-face interview that your loved one will go to, is that you're going to bring them there on their worst day. You don't want them to see them on the day where they're at the highest functioning that they can be. You want to see them at their worst, because if it was that day, every day for the rest of their life, what would be the chances of them holding down gainful employment, living independently, all of those things. So SSI, again, is food, shelter, and utilities. And I know we have some with age and majority children in here, but does anybody know the amount of SSI today in Pennsylvania? Or who wants to guess?
$621?
Close? Anybody else?
$725.
Closer. Closer.
721.
732, what did we hear last week?
33.
733. Don't, yes, they gave us a nice cost of living adjustment.
Most people don't get that.
Correct, and that's a perfect segue, thank you.
I get the lower amount from my son who's over, he's 26.
So hold that thought, because I'm going to come back to that, because that's very common. But $733 is going to feed, shelter, and pay the utility bills of our adults with disabilities.
Good luck with that.
Yeah, good luck. I don't know where they will be living off of that dollar amount. But again, it is a benefit they are eligible to receive. They are not entitled to this, which goes into your point. When, assuming they're still going to be living with you, they're 18 years old, they're living under your roof, you need to start charging them rent. You need to start charging them for food. You need to start charging them for utilities. If you do not do any of this, or you do not report back to the government that you are properly allocating the funds of SSI, what happens is that they will automatically reduce SSI by 1/3, which will leave you receiving $450 to $460 a month of SSI. Now, if you have a loved one that's not working and not earning income, and they are receiving this reduced amount, got a good news for you. What we need to do is appeal. Because frankly, if somebody is living under your roof, they're not earning an income, they should be receiving the full amount of SSI, unless they are earning income and working. So the appeal process is about as fun as the original application process. Probably less fun. So like I said, it's if you want to, you can go down this road yourself and appeal, but there are resources you can tap into. Randy and I can connect you to them. So that's SSI, food, shelter, and utilities, the only three things it can be used for. When you collect SSI, you are automatically eligible for Medicaid. So approval for SSI means approval for Medicaid. Medicaid will be the health care. Both of those, as an adult, your loved one has a $2,000 resource limit to continue to be eligible for both of those. There's another needs-based benefit called waiver. We need a whole presentation to talk about that. If we have time at the end, we'll touch on waiver. But waiver is very confusing. Actually, I believe you had actually told me about the gold book to begin with.
Oh, shoot, I didn't bring it.
You didn't bring it. All right. So there is this publication at the Temple Institute of this, right? Still Temple?
They're out of business.
Okay, never mind. Somebody else is doing it now.
It's still online.
Still online. All right. So Temple is its gold book. It's how to navigate waiver in Pennsylvania. If you like to fall asleep, this will put you right to sleep. It's very tough to read, but it is informative on the types of waivers, what they pay for, all these different acronyms that you're still probably getting used to, IEPs, ASD, ISP, MA, all these different acronyms, but it is free still, right, to parents? Free to parents. It's a great resource to tap into. So that's the world of eligibility-based benefits. The world of entitlements is very different. This is based on Social Security and contributions to that. If someone never contributes off their own work record, the way they collect is off of their parents' work record. So there's three ways an individual with a disability can collect off their parents' Social Security work record. The first way is when you retire. And by I mean retire and collect Social Security retirement. They are entitled to 50% of your benefit. Not taking away from you. This is in addition to what you would receive. If you become disabled and collect Social Security disability, same thing, 50% of your benefit. And when you pass away, they are entitled to anywhere from 70 to 90% of your benefit. And that will be the highest monthly cash benefit they will ever get through the government.
And what age you said that was?
I'll say that in a second. So this is at any age with one key point. So to be entitled to this benefit, this disability has to have an onset of their 22nd birthday or sooner. If they are not disabled or in the system is disabled earlier than their 22nd birthday, they are not entitled to a benefit off of your work record, ever. Which is why this planning has to be proactive, which is why that population that has higher functioning loved ones still needs to go through some of these processes, because this is a huge benefit that if we wait too long, we may be missing out on thousands of dollars for the rest of our loved one's life. So very important. When you collect Social Security, though, after 2 years, you get Medicare. Medicare will then be your health care. You can be dually eligible for both. So Social Security there's a whole other talk about those that are working, and Randy will touch on this, but part of this planning isn't to say, well, let's just plan for government benefits. It's to plan for the best. Working, gainful employment if possible, living independently or living with roommates. You know, having as independent of a lifestyle and living to their utmost potential as much as they possibly can, these things are just, you know, if the worst case scenario happens. These are your contingency plans. So I don't want you to think that we're saying you need to limit the expectations or the potential of your children. It's to say, let's push them to be what they can be, but have a fail-safe just in case things change or government benefits change in the future. So before Randy comes on, this is my suspense building slide. But let's talk about resources first, because with that $2,000, there is a list of resources that do not count towards that. And that list of what's not counted is much smaller than the list of what is. So what can an individual own that is not part of the $2,000 resources? They can own the home that they live in, not a countable resource. They can own an automobile, as long as it's used for transportation purposes. They can own personal belongings like video games, musical equipment, stereo equipment, all that kind of stuff, not countable towards that. They can have up to $2,000 in their name. They can have these accounts called PASS accounts, which were like the predecessor to the ABLE accounts. They stand for Plan to Achieve Self-Support. If you Google PASS with the periods in there, you'll find out what that is. But pretty much everything else is counted.
Burial plot.
Burial plot too. Prepaid burial plots. Cash value life insurance is counted too, so you can't have that. But what is counted is cash, savings, checking, CDs, stocks, bonds, retirement accounts, IRAs, 401ks, college savings accounts, 529s, Coverdales. Pretty much everything in that list is countable against them. So if you have somebody closing in on 18, we have to have a conversation sooner than later about how do we make sure that this money is not in their name come their birthday. If you have a young one, don't wait until they're 17 and a half. The government could technically look back 5 years if they really wanted to for Medicaid eligibility. And if you have a loved one over 18 where they accidentally come into over $2,000 in their name, we'll talk about that in a few minutes. So I'm going to pass the torch over to Randy. Randy is going to now talk about, you can just hit enter to alleviate the suspense. Just enter.
Okay. I'm Randy Steen. I'm an estate and tax planning attorney. So I've been practicing law for almost 24 years, which makes me feel as old as I am. But it is what it is. I've done special needs planning for all of those 24 years. A sophisticated tax and estate planning attorney at my core, which means I do wills and trusts, from charitable trust to special needs trust to international estate planning. So I've done all this planning. I was in private practice downtown. I was in-house counsel for PNC Bank downtown, and I was in-house counsel for Equitable Life Insurance for a number of years. And then during that time, my own daughter was born. She's 7.5, and she has a rare neurological eye disorder, which if I told you the name, you would have never heard of it. So it's kind of no point. So I have my own struggles. Just had an IEP meeting this week, and I think they should allow you to bring shots to it, but personal opinion. So anyway, the name of the game, like Pat said, and I'm actually going to just clarify one thing he said to make sure it's crystal clear. When Pat says that for our kids to qualify for our Social Security income, to get share in that benefit when we start collecting, and he says that they have to be qualified disabled at 22, doesn't matter that they're on medical assistance when they're kids under the age of 18. That does not qualify them. When they turn 18, we have to qualify them for SSI. As adults, they have to qualify to be considered to be able to collect on our benefits when we retire. So between 18 and 22, we have to qualify them. That is the only way they will be able to collect when we retire 50% of our Social Security benefit. Okay. The day that we die, they will be able to collect 90% of our Social Security benefit for the rest of their lives. Okay. Their SSI goes away. So remember that. You'd never get the best of both worlds. So if I retire and my daughter gets 50% of the value of my check, her $733, great as that is, goes away.
We're going to touch about what parent passes away. We're going to touch on that.
Yes.
Thank you.
Yes, but that is what would happen, and then when I die, she would get that amount for the 90% of that amount for the rest of her life. Okay, so just so you understand that, I'd still get my 100% benefit when I retire, and she would get 50% of the value, and that's because I've contributed to it. Okay, that's the way it works. You also get incentivized to work. We get work credits. Our kids get work credits, and in fact, all of my adult clients work. They work pretty significantly. Very few actually only work 20 hours a week. Most work more than that. And the more you work, you can actually qualify for more dollars than the $733 a month, which is in fact a whole separate talk, so I'm gonna get off of that. But just so you know, there are incentives to work. The idea is not to de-incentivize people from working. But to get back to the special needs trust, so the $2,000 is unfortunately a true number, and it is a qualifying number, and it is something that we have to deal with. So while they are kids, they could be millionaires. The day they turn 18, they cannot be millionaires. They cannot have more than $2,000 in their own names, otherwise they will not qualify for benefits. So we have to get the money out of their names, and we have to get it out of their names reasonably before their 18th birthday. Reasonably, I don't know, in a perfect world, at least 6 months before. In an imperfect world, we wait a little bit before we apply for SSI. Do not listen to the Social Security website or anything you read. Do not apply 90 days before their birthdays. Okay, you will get knocked out. They're not 18, 90 days before their 18th birthday. You will automatically get denied. Apply 30 days after their 18th birthday. Okay. But the $2,000 is our resource limit, so we face this problem of how do we possibly plan and provide for their future if they only can have $2,000 in their own name. And how we do it is by creating these special trusts, these special needs trusts, where we can literally leave millions of dollars if we happen to have it, or as much money as we have or we can provide for in these trusts, and make sure that they still qualify for their benefits, and the money there is to provide them for the best quality of life, the best therapies, the best housing, the best opportunities that we can possibly give them. That's what the trust is there for. That's what it does, done right. And I say that qualifying, done right, somebody who does it every day, not somebody who says they do it, not somebody who dabbles in it, somebody who does it every day. So done right, protected correctly, okay, we can have these trusts and make sure that they can get their benefits for the rest of their lives and have all these extra monies available for their use. That is the purpose of the Special Needs Trust. It has to be done proactively, okay? It has to be done professionally, correctly, and it has to be done with flexibility. So by that I mean, if you have existing trusts, take them out, dust them off, look at them. There's a lot of mistakes that I see constantly in trusts. So Social Security law changes, and it changes fairly often, okay? Who thinks Social Security is going to be the same 5 years from now? Anybody? Anybody think the law will never change on special needs trusts during our lifetime? During your kids' lifetimes? Okay? So the trusts have to be able to sort of dodge and weave in case the law changes. And they have to be able to do that whether we're here or not. Okay? So your trust should have a provision in it that your independent trustee, who is not you, because you're not going to be here forever, okay, can actually change the trust to comply with the Social Security law. So that money is always protected. Okay. If your trust doesn't have it, it's a problem. Right? Your trust should also have a provision that says, my trustee can change it for that reason, but guess what? They can't add other beneficiaries to the trust, or not make my kid the only beneficiary. You know, they can only do like really limited things, you know, to it. So you have to be very, very careful, okay? The trust should also be asset and creditor protected, which means that if you get sued, they can't get the money in the trust. Makes sense, right? Something catastrophic happens, they can't get the money in the trust. If your child is influenced to sign their life away, they can't get the money in the trust. All those things are actually pretty important, okay? The trust also has to have a lot of resources built into it so that when you are gone, whoever you pick as trustees has support, okay? Because this is a pretty big job, and it is a lot to ask of somebody, okay? And often we are asking family members, sometimes siblings, sometimes other trusted family members, sometimes we're putting corporate trustees in with people, sometimes not, but it is a pretty big job and it can be pretty overwhelming. And there's a lot of facets of the job that we can hire out. Some are obvious, like we can hire investment advisors, we can hire accountants, and we can hire lawyers. You know, that's pretty easy stuff, you know. Some are not so obvious to people, like the ability to hire professional care managers, the ability to hire government benefits advisors to help us navigate waivers and Social Security and all those things that read like Greek if you try to figure it out on your own. And you need to actually put that stuff in there. So it is written and it's kosher. Okay? It's important that that stuff's in there and those supports are built in there so that your trustee knows that they're not alone. It's also important to pick the right trustees and pick alternatives to those trustees and to give them the supports and resources. And we kind of have to have a deep bench, and not everybody has a number of those people in their lives that they can trust. So a trustee's job at its core is to make sure the money is invested appropriately. In trust terms, that's not too sexy, that's conservatively, okay? That's the law of trust investing. Money's supposed to be there. It's supposed to be there for the beneficiary. It's conservative investing. We're not going to Vegas with this money. It's conservative. So really, if you hire a qualified investment advisor like Pat, you're in pretty good shape. It's conservative investing. The real job is to make discretionary decisions to make sure that the monies are being used appropriately for services, for extra therapies, for extra things that $733 a month isn't paying for. And that's really the benchmark. The trust steps in when that $733 is not enough to provide for the best interests of our kids. It's everything above that. Okay, everything above it. Well, we don't think that $733 is providing enough for the best interests of our kids. We can hit the trust, whether it's therapies, whether it's housing, whether it's cleaning services, whether it's meal preparation, whether it's vacations, whether it's a car, that's what it's there for. Okay? So we need someone in that trustee seat who thinks the same things are important that we do, so somebody who shares our value system in a perfect world. Okay? Somebody, if we could, sort of thinks the same way about money that we do, maybe. They don't have to, it would be nice, you know. I couldn't put my younger brother in because he declared a bankruptcy. You know, they have to be decent, you know, about these things. But what I need more from you as clients, if you become my clients, I need you to pick somebody who is personally connected and invested with your child. I need somebody who loves your kid. I cannot buy that, I cannot outsource that, and I cannot hire that. It's one thing I can't do. Okay? I can hire co-trustees around that. I can support them. I can build them up. But I can't hire that. And that's critically important in that job because my trusts make the trustees check in on them. You can't, in my trust, not check in on that person because I don't know where they're going to be living when you're gone. I don't know if they're, and that doesn't mean institution, so don't get nervous. That's not what that means. I don't know what housing is going to look like. They could be living with a relative. People get abused by relatives. I still need to have them looked in on. I need to know that they have a voice, that they're taken care of, and my trusts have provisions that make sure that happens. Okay? So dust off your trusts. Make sure that your kids are protected in them. So good special needs trusts do all that. Okay? The challenge is, as a parent, to do that piece right, and there's other things that surround it that we'll talk about legally, but to get the trust done right and make sure that there's money in it so that there's enough wiggle room and resources for your trustee to maneuver for your child. Okay? And Pat will talk more about the funding afterwards. But that's the job of the trust, and that's why we do it. There's 2 places we can do it. Okay, we can do a trust inside a will, do a special needs trust right inside a will, and that's the less perfect way to do it. That's the imperfect way to do it. Okay, and we can do it as a separate standalone special needs trust. That is the perfect way to do it, and I'll explain the difference to you. Okay, and you're talking to a tax lawyer, so understand that. The perfect way to do it is the separate standalone special needs trust. It lives today. It exists today. It is its own entity. It is asset and creditor protected from the get-go. Anything you put in it is out of your estate for federal estate tax purposes. It is out of your estate for Pennsylvania inheritance tax purposes. If you get sued, they're not getting it. Okay? It is there. It is also open for business the second we create it. So if anybody wants to make gifts to it, anybody, they can. If anybody wants to leave an inheritance to it, they can. That's the place. Okay, so it lives and it exists. Okay. Normally that's how we do it. It's also the slightly more expensive way to do it. If we have a situation where somebody knows, nobody in the world, and we have this sometimes, is going to ever make a gift, leave any money, and the person has limited resources. So nobody's really going to be doing anything except this person or these parents, and they're going to need every penny that they have until the day they die to help support their kid. And this happens. Then there's no reason, there's no good reason to create a separate trust, because we're not going to really use it. Okay? Then we do it inside the will. Okay? Because nothing's going to really be going into it, or we don't need to trigger it.
If the kid has money, you got to do it.
That's a different kind of trust, and I'll get there.
Okay.
It's a payback trust, okay? So the trust that I'm talking about, thank you, sir, perfect segue, is called a third-party special needs trust, okay? This is the proactive planning trust. Third party in English just means anybody other than the disabled person's money is used to create it. So parents, grandparents, anybody else, anybody other than the person with the disability is creating the trust. Third party, okay? No payback to the Commonwealth of Pennsylvania. When your child passes away, you can leave the money to your other children in there, triggers it automatically. You can leave it to charity, you can leave it to whoever you want. Nobody has a right to tell you how to leave it, okay? Also, nobody really has a right to audit it or look at it. Social Security has started to ask to look at them. We show them to them because it doesn't hurt us to, but it means nothing. They don't have a right to tell us anything about how to spend the money in them, okay? That's the third-party special needs trust, and as parents, that's pretty much what we're doing. As parents and grandparents, we're creating these separate vehicles. A first-party special needs trust, which is what this gentleman is talking about, is actually a mistake in planning. It's happens when, and first-party means sort of exactly what it sounds like, created with the disabled person's money. That's what it means. It's a first-party trust, okay? This happens when somebody very, very well-meaning leaves money directly to our child, to their name alone. They don't know anything about special needs trust, or we try to talk to them and they are not interested in listening to us, okay? They just leave a direct bequest, or they make a gift directly to that child's name. If our kids are over 18, it would knock them out of benefits if they received it that way. Then we have a problem on our hands, okay? So, happens in that case. It also happens if our children are in an accident we have a lawsuit situation, and there's a lawsuit going on. If you're in an accident, you are the person suing, whether you're disabled or not. You are the correct legal party. The settlement comes, it's coming to you. So it's coming to our disabled children. If that happens and there's a chunk of money coming in, that is when we have to create a first-party special needs trust. That is the payback trust. That is when the Commonwealth has a right, when that child dies, to come in with a bill and say, you got to pay back for every service that you've received, every bill, everything. Okay, now, the reality, and they audit those very heavily because, hey, they want there to be money left at the end. They get to come in with a bill, so it makes sense. They're allowing you to, even though you've gotten this chunk of money, they're allowing you to put it in trust, and they're allowing you to get your SSI and your Medicaid and your Medicare. They're allowing you to get benefits. So when you die, it's time to pay the piper, and they want to be able to come in with the bill, so they have the right to audit you pretty heavily and really, really scrutinize what we're spending the money on, and scrutinize they do. Okay, so when I say it's a mistake, I say there's a proactive way to plan, and then there's a reactive way to plan. We can fix it. It's just a question of whether people care very much about how their money is flowing or not. So some people say, it's not that much money. If somebody leaves it outright, it's not that big of a deal because we'll fix it and there won't be any money left to go to the state in that first party trust. And I can assure you, when mistakes are made and first party trusts have to be created, we spend that money first. That's for sure. We try really hard to make sure that check bounces if there's anything, I want to hear the nickels rolling around, But, and it's happened to Pat and I. If I have somebody with $10, $20 million and they don't plan, and it all ends up in a special needs trust, that's a first party trust, and they have other kids, that's not a really great result. It's not a great result, So we can always fix it, but it's not a great result. If you've worked really hard to accumulate your wealth and you have other family or even charities that you would prefer to go to, it's better to proactively plan, okay? The other things that you need in general, and as our kids turn 18, are powers of attorney for finance and powers of attorney for healthcare, okay? At 18, we are emancipated. We are our own people. For good or for bad, we're our own people. We have to make a decision with our kids. Do we want to go for guardianship? Or are we going to do it via powers of attorney? All of us should have powers of attorney in this room for healthcare and finance. The HIPAA laws, the privacy laws, literally say if I'm in a car accident, they are not supposed to speak to my husband without a power of attorney. That is against the law because I have complete and total right of privacy to my medical information. Is it routinely violated? Yes, it is. Have I run into situations where it is not violated? Yes, I have. And we've had to go to court to get emergency guardianships with spouses when one's laying in the hospital. So I can't predict when it's going to be violated or when it's not going to be violated in emergency situations. Yes.
Power of attorney, is that part of the guardianship?
Nope.
Is it
separate? It's separate.
Thank you.
Okay. So power of attorney is something that you sign giving somebody the right to assist you if you need help or you can't speak for yourself. So it's on the medical side. There's also one on the financial side. Same idea, but has to do with money. These are living documents. They affect you while you're alive. At 18, and we should all have them, at 18, when our kids turn 18, we have to decide, are we going to go that route, the power of attorney route, or are we going to go for guardianship? There's a significant difference between the two. There's a significant cost difference between the two, and there is a significant perspective difference, if you want to call it that, okay? So the cost difference is guardianship runs around $3,000 to $4,000 to get a guardianship. Powers of attorney, between $500 and $1,000, depending on the lawyer, to do powers of attorney. So that's significant. Theoretically, I think it depends on what lawyer you go to, and I also think it depends on what their background is and sort of what their theory is and whether they have a special needs child. I really do. So how I feel about it is this. Every day, I do everything in my power to make Sarah as independent as humanly possible. That's my goal. If I do my job right, hopefully the future will be bright for her. I cannot imagine the day she turns 18 of stripping away every single right that she has, including the right to fill out a job application, which is what guardianship does. It takes away all your rights. Interestingly enough, the only right it doesn't take away is the right to vote, which I find fascinating because you're not allowed to fill out a job application, but you can vote. However, it is what it is. So, you have to have capacity in the eyes of the law to sign powers of attorney. And capacity, from a legal perspective, is at the moment you are signing the document, do you know who you are, and do you understand the nature of what you're signing? Okay. You don't have to understand the words in legalese. Do you understand the nature of what you're signing? Okay? Because you're not going to understand the words if I put them in front of you and I don't explain them to you. Because it's legalese. It's not, doesn't read like English. Okay? But if I ask a child, is it okay if mom and dad talk to your doctors and help you talk to your doctors and read your test results and everything? And if they can understand that and say, you know, yeah, Randy, that's fine. That's capacity, because that is the nature and spirit of that document. That's what it is. Boiled down, broken down, down and dirty. That's what it is. Okay. On the finance side, is it okay if mom and dad help you with money and handle your bank accounts and do that with you, those kinds of things with you? The answer is yes, that's capacity. We're signing. We're signing if we're signing hand over hand, we're signing if we're doing a mark, unless, there's one caveat to that, unless somebody is a danger to themselves. That is different. If somebody's a danger to themselves, you don't have a choice. Then you have to go for guardianship.
If you don't have capacity, then the guardianship's the only.
If you don't have capacity, you're at guardianship, okay? Or if you have capacity, but somebody is so destructive and such a danger to themselves, then you don't have a choice. But if there is that glimmer, and there's capacity, and somebody's pretty peaceful, we're going to go with the path of least resistance, because you are not precluded when you do powers of attorney from going for guardianship later on if you need to. You're not precluded. It doesn't prohibit you from doing that. Guardianship, to reverse it the other way, is quite a different story. Because once you get a guardianship, you've been in open court and a judge has ruled that that person is incompetent. You've provided medical evidence to support that fact. It is a different story. Okay? I have only had one case in my entire career that I have told parents that you need to go for guardianship, and they did not listen to me. And it was, I could see it coming a mile away, and the kid became a Jew for Jesus and cleaned him out. You know, he absolutely wiped out every bank account, and they had to go for guardianship. You could see it. He was like a criminal mastermind, you know. You could tell. But they didn't want to say it. One time. 24 years, one time. I know when somebody can sign and somebody can't sign. It's quite apparent to me. I've gotten down on the floor and signed. You can tell when somebody can sign and they can't sign. The most fascinating thing about signing powers of attorney with kids is their parents when we get to organ donation. That's the most fascinating thing with special needs kids. When we get to organ donation, every single time, I've never sat down with kids turning 18 who have special needs where their parents say, they're not going to know what that is. Every time. Well, Randy, I don't know, that creeps me out. Do you know what it is? Oh, I know what it is. Yeah, every time somebody has an opinion on it, and it's usually not what their parents think or not what their parents want. It's very interesting to me, and a lot of times I have to make the parents leave the room because they want to try to influence the kids on their decision about organ donation. It's very, very interesting to me, and those are all my special needs cases I'm talking about. So it's fascinating. But so we do have to make those choices. That's sort of an 18 choice, but if you don't have powers of attorney, you need them. And if you don't know it, the law changed. My client's sitting here know it, but the durable power of attorney for finances changed as of January 1, 2015. Hopefully your lawyers notified you. They, not that your old ones are not effective, but the new ones have a lot more tax provisions in them and a lot more protections against people stealing from you and embezzling from you and things, so they should be updated. Yes?
This is a small point, but it's my understanding that you can't use a power of attorney to actually use your child's social security account.
You would be a representative payee on the Social Security account, not a power of attorney. It's different.
Social Security being in the system, you can't do that either.
No. I think you're misunderstanding Social Security.
I know what they're telling. I know what they're telling us. They may be wrong, but that's what they're saying.
Are you the representative payee?
No, her mother is, but we've been there together with it, and there's language in the documentation that suggests they're right. But to the extent that they've said the only way of operating it is to sit in front of the computer, legally, is to sit in front of the computer and take her finger and stick it on the key So it's her key that finger that operates the key, so it's technically not a felony.
Okay, you're giving them way too much
That's why I'm asking
information.
the question.
Yeah.
So that's very precisely the explanation that was being given.
That makes no sense. Does that make
A
any
lot about
sense to you,
social
Pat?
security officers doesn't make sense.
Yeah, no, it's, when you're a representative payee on an account for your child, you get the money and it is yours to distribute for the room and board and deposit.
Thank you, Bob. Glad I asked the question.
Yeah,
Clarifies that.
that's,
Yeah.
so either you're getting wrong information or the money is going the wrong place.
No, we're getting wrong information.
Yeah, you're getting the wrong information. You can come talk to me afterwards, because it doesn't sound right. It should not be restricted. The money is there to be used for her in any way that is for room, board, utilities, and extra expenses. It's not to be restricted. Okay, so it's silly for them to tell you to sit her finger in front of a computer. Yes.
So if you're special needs child, there's no possibility of having capacity, you're automatically going to guardianship. Is that what you're saying?
Yeah, unfortunately. Yeah,
Why,
unfortunately.
why do you say unfortunately? I guess I'm missing something.
Unfortunately, because I would prefer not to have to do that. I hate the legal idea of stripping them of rights. But if it protects them, then that's what you have to do.
So,
Yeah.
for instance, if they're profoundly handicapped, they can't be
Can't do it.
capacitated.
Correct. Can't do it.
Oh, not even hand over hand, you were saying?
They would have to be able to understand what I was saying and acknowledge to me that they
And if they
understand
can't, then you have to.
it. We have to do guardianship. Yeah.
So I've been her guardian for 37 years, and then all of a sudden,
You're
when
a
she
guardian.
turns 18, I'm no longer.
You are no longer a
even though I'm
guardian.
taking total care of her.
You are no longer legally in the eyes of the
How
law.
does that make sense?
Only when the bills come in.
Well, that's a different
Doesn't
story,
make
yeah.
sense.
Which actually is a good segue, because if you have kids, the other thing that you all need, whether you think you do or you don't, and then I'm going to turn it back to Pat, because we could go for a long time, is wills. Okay, so wills and guardian. If your kids are under 18, wills in Pennsylvania are the only place where you can name guardians when they're under 18. When they're 18, that's when you have to make either guardianship or powers of attorney decisions. But when they're under 18, wills are the only places where you can actually appoint guardians. There's nowhere else in the law to do that. You have to do it in your wills. I suggest you do it. Okay? If you do not do it, it is a problem. I have seen people fight. Everybody wants the kids. Nobody does not want the kids when people die young. It is not a pretty sight to see both sides of families fighting over children. So wills are the appropriate place to do that. Okay? Aside from the fact that most of us have other children to take care of too, other than our special needs children, and we have to figure out how they're going to get their money if something happens to us. Giving them a check at 18 is not a good idea. It will be gone, okay? Giving anybody a check in any large amount at any age outright is not a good idea, okay? I have seen, whether it's 5,000 or 5 million or 10 million, if you hand somebody a check, it is usually gone within 5 years. Like that, and it's because it's found money, it's not earned money. Okay, so it's treated very, very differently by 99% of the people, very, very differently. So it's important to see how assets flow. We also have taxes when we die. We get hit on the federal level and we get hit on the Pennsylvania level. So federal estate tax is 40%. Husband to wife, if you're both U.S. citizens,
That's
is
$5 million.
is zero. Well, yes, it's if you have over $5 million, but that changes. It changes with presidents, okay? And it changes dramatically. When I started practicing law, it was a 55% estate tax, and all you had to do was have $600,000 in your own name. It changes dramatically, and I don't know who's going to be in the next presidential election. So that's my job, to keep my eye on that. We also have a Pennsylvania inheritance tax. That's husband to wife is 0, kids, grandkids, 4.5% tax. No exemptions, $1. Your jewelry, your clothing, if you happen to tell them what you have, but everything. The only asset that escapes it is life insurance in Pennsylvania. We like life insurance, okay? But we have taxes to deal with. It's also important that you have a will if you like your spouse. If you don't like your spouse, a little less important, okay? If you like your spouse in Pennsylvania, you want to have a will, because if you die without a will, they are not going to get all your money. That is not what the law says. Okay? If you die without a will in Pennsylvania, they will get $30,000 and they will have to split the remaining money 50-50 with your kids. They do not get everything. That is not what the statute says. Okay? It's not the way it works. That is a disaster if you have a special needs child, because it means they are handed a check at 18. Guess what? That's the magic age. Guess who's not getting benefits or who's losing money? Plus, should not be giving any kid a check at 18 outright. Okay? So that is a problem if you don't have a will. If you are a single person and you are not married, your kids are not getting all the money if you die without a will. First $30,000 is going to go up to your parents. And you're going to split 50-50 with your parents. It's not the result people want. Okay? You've got to be very, very careful when you're doing planning. So if how your money moves is important, if you have tax situations or issues, you have to think about all these things. Okay? So with that, in the interest of time, I'm going to pass it back to Pat.
I'm going to talk more about taxes, which I know everybody's looking forward to talking about and hearing more about. But Randy talked about that first leg pretty in detail, the legal side of it. I'm just going to jump through to the third leg, which is one of the hardest questions to ask somebody. One of many hard decisions to make is, how do you identify a care provider? You know, who is that person that's going to replace you if you're the primary caregiver when you pass away? And how do you know? How do you know if you ask somebody and they say, yes, I will be that guardian or the successor guardian? How do you know they're going to follow the steps that you would have wanted them to follow? So there is a document. It is not a legal document, but something that will provide a roadmap for those that you leave behind, and it's called a letter of intent. We have a template that we share with our clients to get you started in creating this, because this is your own document. This is what you want it to include for your child. And because it's not a legal document, it does not hold up in court, but it also doesn't cost anything to make. And you know, this is something that will be ever changing as your loved ones change, as their goals change, as your goals for them change. So everything you would want somebody to know about your child, no matter how old they are, and what you envision their future to look like, you write this down on paper. As things like marriage and living situations, work situations. Are you okay with a sheltered workshop, or do you want them to be pushed further into maybe gainful employment? Are you okay with group homes? Are you okay with life sharing? Are you against them? All these important things you put onto this document. You know, I've seen some this thick, I've seen some that thick from clients over the years, but it really helps tie the emotional aspect into this, because you're going to create this special needs trust. You're going to fund it eventually. This is what actually gets it put to use. You know, if they like going to ball games, or like going to shopping, or like going to shows, if their siblings live across the country and you want them to fly back and forth to see each other, or if you want them to go with a companion to fly across the country, these are things that you would want to have a say in, I would imagine. So, very important document, and it's never truly something you finish. It's always working. So the fun part of this, you have a trust, you have a bunch of stuff. I always call it stuff. I'm going to just open it here. Everybody has assets, be it your house, be it investments, be it retirement, be it life insurance. The thing is, there's no right answer to how much of all of these that you need, but I'm going to ad-lib on taxes. And does anybody in this room think taxes will be lower in the future? No. And like Randy said, taxes change. They change like politicians every 4 years. Our neighbors to the east of us, New Jersey, are one of the most expensive states to die in from a state tax level. So the federal estate tax, which is at 5, I'm actually going to write down a couple numbers. And some of them Randy already talked about, but again, it's a good note-taking section if anybody wants to write anything down. So a couple of key figures. You got 0%. $5.43 million, and that's times 2 if married. 40%. And then I apologize, my handwriting was never one of my strong points. 4.5%, 12%, 15%. And then this last one, all the way down to the bottom, and I'll talk about these so you don't have to look around me, 30 to 40%. So I always talk in approximations, never definitives in the financial planning advice that we give, because these things change. But Randy addressed two of these. There is a 0% tax, spouse to spouse. So no matter how much you leave to your spouse, as long as they're a natural citizen, there's a 0% estate and inheritance tax on those dollars. Right now, every American has a $5.43 million federal estate tax exemption. Married, it's about $11 million. So if you look at these asset classes here, and you add up what you have, it's not about what you have, and it's not only about how these things grow, what you're invested in, what your real estate appreciating by. It's the knowledge that these things are eventually going to be taxed when we leave them to our loved ones. And like I said earlier, it doesn't matter if you leave it to a special needs trust, the government is still going to tax it, and in some cases tax it worse than they would to one of your neurotypical heirs. So that's where we get into these other realms. So Randy said the tax on the federal estate tax is 40% on anything above this. She said the tax for direct lineal descendants in the state of Pennsylvania on an inheritance tax is 4.5%. Parents to children, grandparents to, I think you can do grandchildren, right? Siblings, it's a 12% inheritance tax. Everybody else, it's a 15% inheritance tax. It counts everything on that list except the value of life insurance that you own on your life in our state. But if we look at our neighbors to the east, New Jersey, they tax everything above $675,000 at a 16% state estate tax rate. That counts every dollar of life insurance. You have $1 million life insurance policy, a term policy, you die, guess what? Your kids are going to be paying an inheritance tax if you live in New Jersey. Who's saying Pennsylvania doesn't turn into that or turn into something worse than that? Everybody knows there's a multi-trillion-dollar deficit that's continuing to grow every second. They have a neat website you can go to see that. But we have to be mindful of these things. What I think is the most overlooked financial planning aspect when it comes to special needs is this 30 to 40, technically 38.6% tax. And this tax is this nasty little acronym, not to add to your other list of acronyms that you know, but it's called IRD, if you can't see that. Does anybody know what IRD stands for? Income in respect of the decedent. So when you look at the different types of things that we can leave behind, from a tax efficiency standpoint, when we look at these, so your property values, your real estate, your home, when you pass away, your heirs are going to pay a 4.5% inheritance tax.
Can you repeat what IRD stands for?
Income in respect of a decedent. So property, 4.5% inheritance tax. Non-retirement investments, or if you want to think of these as taxable investments, same thing, 4.5% inheritance tax. There are no income taxes on those types of accounts because they receive what's called a step-up in cost basis when you die. We're going to come back to retirement funds. Life insurance, not countable for the Pennsylvania inheritance tax currently. It is part of the calculation for the federal estate tax, but again, you're dealing with a pretty high exemption. I'm going to add another account. It's called Roth accounts. So Roth accounts are funded with after-tax dollars and they grow tax-free. So when you take money out, under certain stipulations, every dollar comes to you income tax-free. Roth accounts, when you pass away, it's a 4.5% inheritance tax to your heirs. We're talking just children or grandchildren, but no income taxes. So pretty efficient. So that leaves us with all these other retirement accounts, the ones that are pre-tax, the ones that we get a tax deduction on every year we make a contribution. If we're payroll deducting our 401k contributions, those are called pre-tax because we get to forego taxes now to pay taxes at a later date in the future. Going back to what I started with on this tax conversation, I didn't see a single hand go up that thought taxes would be lower in the future. So if we are deferring all of our income taxes for the future, what's the risk to that? Higher taxes. If we defer all of this income to our heirs when we die, guess who gets stuck with that income tax bill? Our heirs. And if we look at, if you have a child with special needs and you have a special needs trust and you have your neurotypical heirs, anybody that receives a retirement account, a pre-tax retirement account that is a non-spouse has three options. Option number one is they can take it out all in year one. So let's say you leave a $500,000 traditional IRA to your child, they could say, I want my money.
Lump sum.
Lump sum, $500,000. $500,000 gets added to the rest of their taxable income for the year, and that puts them right up into this 38.6% income tax bracket. So roughly 40% of your hard-earned sweat dollars that you contributed to your employer, 40% of them could go to the government year one. Ideally, that's where people like us come into play to say, either no, you can't because there's a trust receiving this that says you can't do that, or to say, look, at the taxes you're going to have to pay, you do not need this money right now, let's think of these other two options. Option two, while not as bad, but it's not that great, is that they take it out over 5 years. So they stretch the income taxes over that 5-year period. Still pretty big chunks, but it's not as bad as in year one. And then the last option, which is called a stretch or decedent IRA, means that they receive your money, that $500,000. The IRS says you need to take out a certain percentage of it every year, 2 to 3%. They take that out, they pay the taxes on it, the rest continues to grow for their lifetime and potentially for their children's lifetime. It's the most opportune way to leave a retirement account. A special needs trust does not get option number 3 in most cases. The reason for that, if you leave this $500,000 retirement account to your special needs trust, and these distributions are required, if they get a distribution of $10,000 to $15,000 a year, what could that do to their government benefits? $2,000 resource limit, right? So that and the income could make them ineligible for government benefits, depending on what they're on. So when you leave a pre-tax retirement account to a special needs trust, all those income taxes are going to come in due right now. So it's a big chunk if we don't do this properly. So when I said the type of things that we invest in, the type of accounts that we use, the type of even securities that we invest in, it's all different with special needs because we have to be mindful that this is multi-generational, that there will be taxes, and the tax situation, we can't evade them. It's very difficult to avoid taxes. We just need to come up with a strategy that we're going to pay them. So whatever you have to work with, our job is to sit down and look at your unique situation to say, we need the trust funded today if something happened. Hopefully that trust doesn't need to be funded for many years down the road when you pass away or the last caregiver dies. So we need to make sure that there's enough today and enough in the future. We'll come back to that one. If we go back to the quiz, have you named a beneficiary of a life insurance or retirement account, your loved one with special needs? It doesn't matter where they get the money from. If it comes from a beneficiary designation or an outright bequest, that money is still going to disrupt their government benefits. So the follow-through, the coordination of this planning is that you do the planning with the attorney. Your attorney and your financial insurance or investment person are talking to say, okay, this trust is in place. We need to update the beneficiaries to specifically read this verbiage to take into consideration the trust that you just spent. You just invested your emotions and your money into creating. So we need to make sure your beneficiaries are correctly updated to reflect whatever planning that you do.
So if you mistakenly miss one, right, because there's a lot of them out there to look for.
Yep.
And it seeds, it provides money to the child. Are you in that first person situation where you need to kind of scramble to remove the asset?
Yeah.
Is that where you end up?
Yeah, Randy can add on to this, but when you have contracts, anything you specifically state into something to go to somebody, that avoids probate. It avoids your will. It avoids any trust that you have. So yes, in that case, the money's in their name. If they're over 18, they have to fund a first-party trust to continue their eligibility. Is that okay from a legal standpoint? Good. All right, so go ahead, Larry.
Isn't it better to leave that testamentary trust or the testamentary money to life insurance? Isn't it better to leave it right to the third-party trust?
Exactly. Yeah. To the trust, you would say to the trustee of the John Doe third-party funded special needs trust created on this date, tax ID number, yada yada yada. That's how you would leave it, so it goes to the trust the right way. So that's where it's it's a lot of behind the scenes work to make sure your accounts are then titled correctly. And Randy said something earlier. When you have other heirs, one of the other hard answers you're going to have to come up with is how do we equally leave our estate behind to everybody? And what I've learned is equitable doesn't necessarily mean the exact same dollar amount. So when you look at the stuff that you have, the assets, and you have some life insurance, maybe you have some Roth IRAs or non-taxable investments, and then you have some pre-tax ones, those pre-tax assets are better left to the other heirs, while you structure the other assets to go down to the special needs trust. So if you want to leave things equal, it's not 50-50 of every account. You just look at everything as a whole and carve it that way. and do it in a tax planning, from a tax planning standpoint. There is one unique type of life insurance I try to spend some time on, which is because it's not commonly talked about. It's, in most cases when people buy life insurance, it's a policy on one person and it pays out when that person dies. You get different types, term, whole life, universal life, variations of those. But there's a unique type. It's a unique type used for estate planning. It's for legacy planning or tax planning. It's called survivorship or second to die. Now this could be a way you fund a trust. It doesn't necessarily have to be. It makes it difficult if you're married, if you're divorced, but divorced spouses can still do this if things are amicable. Grandparents can do it, aunts and uncles can do it. But this would cover the two people under one contract. It's typically less expensive than both individuals getting a permanent policy on one another. If one has health issues, what happens is they combine the risk into one, and it could be more favorable than that unhealthy person trying to get insurance on their own. And this pays out at the second death. And if you have two parents who are the primary caregivers, when is that money needed the most? It's needed at the second death, when the last caregiver is gone. A hurdle families have is, well, I don't have hundreds of thousands of dollars, $1 million to put into a special needs trust right now. You don't need to. You don't need to put a dime into it necessarily right now. You just need to create it just in case. You need to set it up so it's funded eventually, which is hopefully a very, very long time down the road for everybody in this room, right? We want to live as long as we possibly can. That's the best plan. So this could be structured as a way to say, this is something we know will be there to fund the trust, and it's part fund the trust, but part pay these taxes that we know are going to be inevitably due. So I like to share that just because it's not something that most people hear about. How much do you need? The $1 million question. This slide does not do you any justice because I asked about taxes being lower in the future. Who thinks government benefits are going to be higher in the future?
You know, Pat, I'm going to actually jump in. I just want to add to something because as soon as we start talking about paying premiums, I think people get nervous. You know, about how, like, all right, where's that money going to come from? You know, we're already paying so many things. So some people, it's not an issue. Some people, you know, have the money, it's not a problem to pay premiums. But sometimes we also need to leverage different things and leverage wealth. So what a lot of people do, and even if they already have an existing policy before their kids are 18, what a lot of people do, once their kids turn 18 and qualify for SSI, is that $733 a month. I don't actually have one client that actually charges their children room and board. You know, most of them are pretty generous and let them live for free. They don't really charge them that money. So what most of my clients do is take, I don't know, Pat, what do you think? Like 500 is most, somewhere around there?
Yeah.
In that range, they use some of that money every month to put towards a premium or pay a premium or enhance a premium on a policy specifically for the special needs trust to either fund it or base fund it or up the funding of what is going to pay into it when they're gone. And initially, for most people, that feels slightly icky because they feel like they are taking something away from the child at that moment because that is their benefit. But ultimately, it is only for that child, and it is a way of leveraging it significantly. And that is part of what we do to leverage money. And I'll give you a personal example which dovetails right into what Pat's going to talk about next, which is when my daughter was born and she was diagnosed at 7 months old, the first thing we did, of course I did the trust because I could do it for free, so you know, I did that. And the next thing we did was buy $1 million worth of life insurance because we had 2 older kids that were going to be going to college within 2 years back to back. And we had no idea, you know, how much it was going to cost and what we were going to do and everything. So we weren't going to start moving other money into the trust. We needed to keep our hands on things. So we bought life insurance to make sure that if something happened to us, there'd at least be $1 million there. And it wasn't any kind of sophisticated analysis. Pat's a lot more sophisticated than me. He's the financial guy. But my unsophisticated legal and parental analysis was, if my husband and I died and there was $1 million in there, not doing great, but if it was invested okay and threw off 5%, It would be $50,000 a year. Sarah'd be able to live. She wouldn't be rich, but she'd have a roof over her head and she'd be able to do okay. Since then, I don't really love the way Social Security is going, and $733 doesn't seem like a ton to me. So, you know, we've since upped it because the older one got a scholarship to the Naval Academy and the other one got a different scholarship, so we were lucky, you know, but that's how you do it. You sort of reassess and look at things and leverage things. But we use a lot of different strategies to look at things and back into numbers to make it all work. And it is really important, as important as it is for you to go to a legal expert, it is just as important to go to a financial expert that understands what assets are appropriate for a special needs trust and what are not appropriate. I've seen many, many mistakes, as many mistakes on the financial side as I have on the legal side, of things being designated improperly to a special needs trust and having very, very poor effects afterwards. So it's important to work with experts.
Yeah, that's why I just got off that slide, because like Randy said, it's what you want to have the lifestyle look like for your loved one. And government benefits are rocky. Oh, yeah, go ahead.
Attorney Randy, when my child was born, I tried to put them on my life insurance. And one of the things the agent asked me if the child had any illnesses or anything, and I said, no, the child was perfectly fine, healthy, got a good rating when they were born. But I mentioned they had this disability. And then I got a letter from the big insurance company that said, no, we're not going to insure that person.
Yeah, you can't, there's not life insurance on my daughter because there would be no benefit for life insurance to be on her. I need to insure my life so that something happens to me, there's money there for her. Yeah, they're not going to insure, yeah.
Beneficiary is fine, but getting insurance on a disabled minor is very difficult.
Very difficult.
Down syndrome is impossible in most cases till 18. But there's really, like Randy said, what is the financial benefit of getting insurance on somebody with a disability? It's really the caregivers who need the insurance on them.
And it depends on the disability.
Yeah.
So my daughter, having nothing to do with the funding of the trust, because to get life insurance on her and she died, there'd be no reason for the trust. But we do have a life insurance policy on Sarah, and she was insurable only because they don't understand what she has. That's the only reason why she was insurable. And we actually use it as a different strategy. We got insurance, permanent insurance on her to build up cash value, not for the death benefit, but because they don't include the cash value of life insurance on the FAFSA form, if anybody has done financial aid forms for their other kids in college. So we used it as a leverage because it's not a countable asset for us. But, so if you have a kid with an autism diagnosis or an ID, just an ID diagnosis or something like that, you might actually be able to get life insurance on them. But Down syndrome, unfortunately, is one of those things.
But did I have to mention that?
You do. Yes, you do. You do have to disclose it. Otherwise, they wouldn't pay it. So there's no point in not disclosing it. Yeah.
All right, so I'm going to dedicate the next 10 minutes to this ABLE Act. And the reason why we've started talking about this is this act is causing a whole heck of a lot of confusion. And I think it's confusing people to the extent of what they need to do from a planning perspective. There is a kind of a bullet point, frequently asked questions piece that we have provided today on the ABLE Act. But who has heard of the ABLE Act? All right, and no judgment aside, who thinks the ABLE Act is a good thing? Less hands, okay. So,
who's not sure?
Yeah.
Yeah. Who's right in?
All right, so by the end of tonight, hopefully we'll make you a little bit more sure on this thing. So if you read anything on this prior to Obama signing it into law at the end of December, every major disability organization was backing it. You know, Autism Society of America, the Down Syndrome Congress, they were all backing this. They all were touting this thing like this is going to be the miracle cure to funding for adults with disabilities. It's tax-free. It's like a 529 account. All of the headlines talked about these things that on the high end, they sounded really good. But when you start digging into the details of this act, the accounts themselves, comparing them to the other ways that we can fund for an adult with disabilities, You get to see what these accounts really are. And I am not saying that these accounts are bad in every situation. They are going to benefit a population of the disabled community. And honestly, I think that the Down syndrome community predominantly is going to be one that's going to be able to benefit from these types of accounts for adults. And I'll tell you in a few minutes kind of why my rationale is behind that. So on the board behind me, you see that these are the ways that we can fund for a loved one with special needs. I guess that's the fourth column where it says ILHBWD. This was prepared by one of our legal partners out in Illinois, so disregard that column. It's not applicable to what we're talking about. So we know we can put money in their name. There's an unlimited amount you can put into somebody's name. However, we know we're going to jeopardize government benefits at a certain extent. So if you go down the first row going across the side, in an individual's own name, they have $2,000 plus any exempt assets like the house, the car, personal belongings, that sort of thing. Third-party trust, Randy talked about. Unlimited amount of money can go into it in any given year and over a loved one's lifetime. Same thing for that first-party or accidental special needs trust. There is no limit. With an ABLE account, sorry, this is accountability for SSI, but for an ABLE account, there is an annual limit of $14,000 that can be put into an ABLE account. But for SSI purposes, an ABLE account, the benefit of this is that this account can have $100,000 in it, and that individual will still be eligible for SSI. So up to $100,000 before they lose SSI. That's not necessarily a bad thing, right? So it's higher accountability limits for SSI. Even higher for Medicaid, which is the next row. So $350,000, I believe it's the same in Pennsylvania. And by the way, no state's enacted one of these yet. The president approved them, and no state's actually signed off on creating one of these. So $350,000 to lose your eligibility for Medicaid. And honestly, Medicaid is the benefit we need to be more concerned about losing. $700 a month is a drop in the bucket. Medications alone could be $7 grand a month. That's the benefit we need to keep. So those are the positive things. Everything else is not so much positive, denoted by the red that's on here. So I already talked about the $14,000 annual contribution limit. So if we need to put enough money into something to provide for lifetime care, how many years is it going to take at $14,000 a year to actually accumulate a sizable amount? A good amount. And we don't know if we have time on our side to do that. So the annual limitation is restrictive. Here's the big kicker. There is a payback on ABLE accounts. For an individual's own name, it's after age 55. Third-party trust, none. That's why that's the type of trust we want to create. A first-party special needs trust, there's a Medicaid payback on every dollar of Medicaid benefits paid out from birth. Okay? On an ABLE account, it's every dollar of Medicaid payments paid out from the account establishment date forward. So that's kind of the difference between the two. But either way, every dollar that goes in there is subject to a payback to the government. Not necessarily a good thing. Allowable expenditures. In their own name, they can spend it on whatever they want. In a third-party special needs trust, they can spend that money on pretty much whatever whatever is going to be used for the benefit of the beneficiary of that trust. First-party trust, the way it was explained to me, first-party trust has to be used for the sole benefit of the individual with a disability. So remember I said trips across the country to go see their siblings? Third-party trust can pay for them in a companion. First-party trust just pays their ticket. That's how I've kind of understood it. So, but as you can see, it's pretty flexible what it can be used for. An ABLE account has to be used for these disability-related list of expenditures. On that frequently asked questions, you have a list of some of them. So it's restrictive on how and what it can be used for. Not a good thing. So these taxes are an illusionary benefit. Because we all have our standard deduction and our personal exemption, roughly the first $10,000 of income that anybody has or that's generated from a specific account is exempt from all income taxes because of that, because we have this graduated tax system. So in a third-party special needs trust, because the trust itself also has a $4,000 exemption, first $14,000 from a third-party special needs trust, that income that's earned is not subject to any taxes. So figure this, 100 grand needs to be in there earning 14% for any income to actually be taxable from a third-party trust. A first-party trust is a little bit different. The trust itself does not get an exemption. It's the individual, the beneficiary's personal exemption and standard deduction. So in that case, the first $10,000 is free from tax. So with this ABLE account, going back to those numbers that I used, If it is used for disability-related expenses, the monies come out tax-free on earnings. But that account itself would have to be generating more than, $14,000 a year in income for it to really have any tax benefit. So it's got to have a pretty good chunk of change in it before taxes even become part of this conversation. So all the government was talking about with tax-free and all of that, really what do they mean? So the last thing here, required reporting, if you can see this down at the bottom, in their name, in a third-party trust, there is no required reporting to the government. First-party trust, at the government's request, you have to disclose reporting. For an ABLE account, every expenditure is required to be approved. So, in summary, compare an ABLE account to a third-party funded, standalone special needs trust. Which account would you rather put your own money in for your loved one with special needs? Show of hands who would put it in a third-party special needs trust. Anybody still like the ABLE account for that reason? No? So here's where the ABLE account comes into play and when it can be used, and I'll get to a slide. Plan includes, oh, okay, gotta go back. So if an individual is working and they haven't earned income, there you go, here's your options. They receive an inheritance less than $14,000 a year. Because it's under that $14,000 annual limit, instead of having to go through the legal expense of creating a first-party trust, you can fund an ABLE account with that type of inheritance. The same thing with any kind of settlement, litigation, malpractice, something like that, under $14,000. That could go into an ABLE account as opposed to a first-party special needs trust, right? Because it's in that individual's name already. We can't fund those types of monies into a third-party trust. The beneficiary has unspent SSI or SSD, which is Social Security, if they're collecting off their parents, or earnings that push them above the $2,000 resource limit or getting them close to them. They can put their own money, their own earnings, into an ABLE account. So the only individual really that should be putting money into an ABLE account is the disabled person, him or herself, from their own assets. Other than that, you're not incentivized to put your own money or anybody else's money besides your loved ones into an ABLE account if you have a properly drafted third-party special needs trust. Does anybody have any questions on it? Is that a pretty good high-level overview of these things?
The inheritance, is your house included in that amount?
If the house is left to them and it is their primary residence, no, it's their primary residence. But if they were left $14,000 in savings, yes, that would be an accountable asset against them.
So if they're not living in the house,
then the house is countable. So and that's a big point because say they are living in you leave them your house.
Right.
And we're talking doomsday, so 90 years from now you die.
Okay.
You leave your house to your child. They live there,
Right.
but they can only live there for a certain number of years where that house is too big or they can't keep up with the upkeep. Then they move out and they move into some sort of group setting. Well, the value of that house now is countable against them. So even though it originally wasn't, if you leave it to the third-party trust in the beginning, which you can own, it's actually a better way of going about doing it. So please share this information specifically with the other families that you know, because like I said, the Down syndrome community is one that could benefit from this because of the higher functioning and the employability aspect of adults. But that's what we have to talk about in terms of any kind of structure.
That was my comment.
Okay.
Because Down syndrome, higher functioning Down syndrome can hold employment after 18. Not all of them, some.
Yeah.
That's why it would benefit them, so they could fund their own account.
Correct. And here's the other thing. So say you have a son or daughter.
My daughter.
So your daughter's 19 years old. She's working at the mall at a store. And she has now accumulated more than $2,000 and she's going to be in jeopardy of losing her SSI. You could tell her, well, you could put your money into this ABLE account and still get your benefits. But you can't use the money at the mall. You can't spend it on shopping. You can't spend it on video games. You can't spend it on fun stuff. You have to use it for something disability related. You think she's going to be jumping at the chance to put her money into this account?
Maybe we'll just go to the mall.
Yeah.
Can she fund her own third party?
No.
No. Okay.
I'm going to say this, and this is not with any kind of legal or financial planning hat on this. The money that you charge your sons or daughters rent or room and board or food, to kind of alleviate this, there are some other ways around this. Say they are encroaching upon that $2,000. Well, they can pay you for reimbursement of things that you spent money on for them. You can charge them rent of $600, $700, $800 a month. room and board and for food, things like that. That way the money comes to you in the form of those checks. It's in your name. At that point, you can use it however you like. You can create, you use your son, John. You can create a Jonathan account, where in your eyes, and you know it's his money, but in the government's eyes, it's tied to your Social Security number, so it's not his, it's not countable against him. But in that instance, you can use the money pretty much with unfettered access to benefit your loved one with special needs. So again, going back to these accounts, I mean, there's going to be a very few instances where it really does make sense to fund these ABLE accounts with dollars.
Yeah, and our clients do that all the time. We have those side accounts that we have paid on death beneficiary designations that were right back into their special needs trust. So if there's other kids, it doesn't get lost in the shuffle. We make sure they go back exactly where they're supposed to go back. Yeah.
It almost seems like these ABLE accounts, it's a way for the government to try to recoup some of the costs that they're spending on the kids.
Maybe. I don't know.
Isn't everything the government does an eventual way to get money back in the future?
Capture some of the costs.
I'd rather have them than not have them, but it's limited use for most of us.
So we're going to be here, I mean, they're kicking us out at 9. We're going to be here for plenty of time for questions and answers, which we're going to open the floor up to here in a minute. But just a quick show of hands. How many people learned at least one thing today? Who needs a glass of wine? That's one thing we forgot to bring. Maybe they haven't.
I don't think before I got the peanut butter ice cream, but I'll take one.
Before, if anybody has to get out of here, remember, if you have your evaluation form, you can give it to Isidore in the back. But please share all of this information with families that might not have been able to make it tonight.
I heard from a Montgomery County-based attorney that you can just take $20 and put it into your special needs trust beforehand just to make sure it works. What's your opinion?
Put $1 in your trust.
Beforehand, before it's actually the day you pass away or whatever.
It works. It lives the second you sign it if it's done right. You can put $1 in it, it makes it effective.
And a third-party trust doesn't need approval from the government.
No, so it works.
First-party trusts do. They have to be approved by DHS before they're enacted. I mentioned Roth IRAs. Hopefully you were being educated on some of the changes recently with Roth accounts. So prior to 2014, there was an income limitation for making Roth contributions based on adjusted gross income. Right now, it's not a loophole, but there's a way around that. It's an extra step that we deal with on the back end. So right now, every individual taxpayer, regardless of their income, can make Roth IRA contributions. If your employer does not offer a Roth 401k or a Roth 403b, now you have an avenue to put money away on a tax-free basis. Back in September, they passed a rule on how you can convert after-tax contributions to an employer-sponsored account. So in most 401ks, you can put money in there 3 ways: pre-tax, Roth, or after-tax. So if you can make after-tax contributions to your 401k, this new law says you can take those after-tax contributions out and move them directly into a Roth IRA. So you can put up to $52,000 into an employer-sponsored account. If you're not maxing it out and they allow after-tax contributions, this is a great way to build future tax-free income for yourself, but also for another way of funding the special needs trust. And if you want more information on that, come see me and I can give you the act to go get the details. Go ahead.
I think I saw that you're on the marketing committee for Planet PA.
Yes. Well, there's not so much of a marketing committee left anymore, but yes.
Did some stuff with Planet PA years ago, and it's also lapsed around. How do you find them?
Care management is extremely important. There are only a few agencies out there that will do care management. Without going into too much detail, I think there's some things that need to be corrected in their leadership there. But hopefully over the next 10, 15, 50 years, more and more agencies are going to be around that can offer these types of care management opportunities. If you want an alternative to Planet PA, I can give you one.
That'd be good, yeah.
He's wearing a coat in the back corner there. So he can give you his overview. Anybody else have questions? Go ahead.
I have a question, and I think it's for you.
Sure.
When we were doing some financial planning, we were given the number of a legal shield that we could go and do I guess it's kind of on the computer. It's a company out in Pittsburgh. You can go and do a trust or would you say that that probably is not the best way to go?
Yes.
I would have concurred with that too. It wasn't Achieva, was it?
Yeah.
Pardon me?
Achieva?
No, it was called Legal Shield, I think. That was the company.
Yeah.
Yeah, it's this company they have that people can have a retainer, you can go and do like legal documents.
Yeah,
Legal
usually.
Yeah.
Yeah.
Legal Zoom, I've seen that too. You can do LLCs, you can do all kinds of
Yeah,
stuff.
usually they don't touch special needs trusts, usually. I mean, usually even like the unions, prepaid legal plans, anywhere in the city, they won't touch a special needs trust, usually, because of the liability involved if you get it wrong. Usually they won't, because they all come to me. But in general, prepaid legal stuff can't think for you. It's not a human being. And they're not tax lawyers, so they don't have all the tax provisions and the bells and whistles. Where sometimes you can get away with it is with some of the state-specific powers of attorney, for like a healthcare power of attorney or something like that. The financial powers of attorney, now that the law's changed and the protections are quite different, they've sort of ratcheted it up. I'm not sure, I haven't seen anyone come out because every lawyer's sort of doing different things in different forms, so I haven't seen any canned versions yet, so I don't know how good they are. I think you can get away with it with healthcare powers of attorney, not sure so much on the financial side, but I wouldn't trust it for a will or for anything else, unless it was very, very basic. If you were, super young with just a healthy kid and just naming a guardian before you went on a trip or something, it would be better than nothing, because it would be like a Band-Aid, but not more than that. It's not the kind of thing you want to create that kind of mess.
One more question. Sure. My son was in a car accident at one time, and he got a minimal amount, like it was like $10,000. So we had to become the guardian.
Yep.
Now, if that money is gone, do we still have to reapply to be his guardian each time? I mean, like the court would send us papers like every year or so and say, how is that money still there, and is the money gone? Is the money gone? Yes, and
just tell the court the money's gone.
So we would not be guardians anymore?
No, it's guardian over that money. That didn't appoint you legal guardian in general. It was just guardians over that money.
Okay, so I always thought we were still guardians because we had to pay like $30-some every year to reinstate this. But no, okay, so then I can just go for power of attorney, and that would be it.
Yes.
So we have this whole thing set up. Is it good? I don't know. We did it, right? In fact, I met you down at the Timothy School in Berlin about 4 years ago. How often do you suggest you dust the thing off, right, and take a good look through it? Because, like you said, laws change, things change, and I don't even know. It's hard to really piece together whether it's the best it could be. Yeah.
What we do, how I run my practice is I offer to sit down with my clients once a year. Not everybody takes me up on it every year because it's not necessary every year, but the offer is out there on a complimentary basis. So it depends on what you feel, Most lawyers don't do that, so it just depends on how people run their practice. But if you're not sure what it says, or if you're not sure if it's good, you need to look at it.
Yeah. Is there a point where you tell your clients, you're not taking me up on this offer for 4 years?
Yeah.
It's time to really.
Well, usually by attrition, it happens. So it's every 2 or 3 years, or like this year, everybody got notified of the ABLE Act and the powers of attorney changing, or some things going on in their life where I'll get a phone call about something. That's what happens. So usually you're not out of touch for that long in my practice. Something comes up.
Right.
That's what happens, because I'm constantly in touch, because the tax laws change every year, so they're constantly getting updates and things. So hopefully you've heard from your lawyer in the last 4 years. Maybe you haven't,
Maybe.
but hopefully, you know.
And I'll add to that too. One thing, you know, this isn't a relationship-based thing you want to get into with your financial advisor or your attorney. You want somebody that's in touch with you, updating you on these things, not creating an estate plan and saying good luck and hopefully you do everything right.
Yeah.
But we don't come to these presentations expecting to replace existing relationships that you're happy with. But yeah, like Randy said, there have been major tax changes since 2010. So that would be a reason to update things. But it's, look at this, if you had a child turn 18 since you would work with your estate planning attorney, and did they call you saying, what do we do about power of attorney or guardianship? Or did they let you know about the ABLE Act or the power of attorney changes? These are the proactive things you want your advisors to be doing with you as well.
Yeah, honestly, it's a set of documents that were drawn up, and we really have no standing relationship with the attorney, right? It was a one and done thing, just to make sure I had documents.
I want to brag, but we have a standing relationship with our attorney, and we got, what do we get, a postcard, you know,
Yeah,
saying these are changes, if you want to talk. We don't want to talk to her, so, you know, we didn't contact her. But the option's there, and that's nice to know, because, I don't know, you know, it's a scary world.
Yeah, but it's if you, I always say this, if you have a relationship with your lawyer, you like your lawyer, set up a meeting, go back, go over stuff. If anybody wants me to take a look at stuff, it doesn't take me very long. I'm happy to sit down and take a peek at it.
Fortunately, you did that for us, so we were thankful for that. So we at least had some sense of peace that what we put in place was decent at that time, right? But time has passed. It's been 4 years. So.
Well, the trust doesn't change that much. You know, that's solid. It's solid. Right. Power of attorney laws changed. The financial power of attorney laws changed. So the main change in that, just so you know, is powers of attorney laws used to always say you got to be prudent with my money. You have to keep it separate from your assets. You can't steal from me. You know. You have to invest it wisely, all that kind of stuff. New power of attorney laws, and Pat just handed me his, so finally, I just took a month for him and his wife to update them. But new power of attorney laws say you have to do all that and, okay? You have to do all that and the person who's sitting in that seat who's doing that job for you not only has to invest your money appropriately and do all those things for you if you're disabled, but they actually have to spend the money the way you spend your money, whether they like the way you spend your money or not. So if, for example, my paralegal has 2 sons, one is married, he's got a family, he's great. Our other son is 38 years old, he delivers pizza, he lives in the basement, her basement. She doesn't charge him rent. Older son thinks he's a deadbeat. Maybe that son has depression problems, maybe he doesn't, not really diagnosed. Older son's her power of attorney. What do you think is going to happen if she becomes disabled? What do you think the first thing that he would do is kick the other one out, right? Under the old law, that would actually be okay. There's nothing that says that's wrong. Under the new law, he is not allowed to do that because it's not his money. And the job is to spend her money the way she spends her money, not the way you think she should spend her money. And that's written in the document. That's a pretty important distinction. Okay, because you don't get to make judgments on how somebody else spends their money on the power of attorney. That is not your job. And under the new law, there's a lot greater accountabilities and protections. So, depends. These things become important, you know.
Any other questions?
I'm kind of in a weird situation. My mother, my son's grandmother, set up the special needs trust, and then my brother, just for some situation, he's actually the trustee. But I don't know as much about it because I was somewhat involved, but I wasn't really that involved with it. It's just there, and she's funding it, which I want to ask you about in terms of, you know, what's more important. Where was I going with this? I'm sorry.
You weren't involved in the planning of it.
Yeah, I know. I'm not involved in the plan. So, like, you would maybe, like, if I talk with them, is taking a look at this. Now, she's in New Jersey, so doesn't matter.
It's federal law.
Okay, so that's the federal. Okay, that's one of the things. I was like, well, she's over in New Jersey, and it was kind of done over there and that type of thing. If that would make a difference.
Federal law.
Okay.
Yeah. But I will tell you this. Okay, doesn't matter. You can have more than one special needs trust. Okay? It's not like an ABLE account. You can have, there can be a number of third-party special needs trusts, okay? It's cost efficient if everybody agrees to have one, because who wants to pay legal fees to have multiple trusts? But you're not prohibited from having more than one. So often in divorce situations, we see parents each having their own because one parent will want to have as the trustee managing the money, the other parent would be caught dead having as the trustee managing the money, and I'm not going to give you control of my money, and you know, that's what happens. So just because your mom's doing that, that's fine.
Yeah.
She can do that, and if you like and trust your brother and want to add to that,
yeah, well, that's
fine.
We just, we try to add, and that was just...
But if you didn't, you could always do your own. But if that's good, there's no reason not to use it.
Okay,
You know? Yes.
Speaking of cost efficient,
yes.
Are your fees high just to set up this address?
Well, it depends. Yes.
I mean, what do you start at? Like, what is...
It depends. So I work on, document work is done on a fixed fee basis. So when I'm litigating against the IRS or in a will contest case or things like that, or in an orphans court, that's hourly. That's hourly. That's $3.75 an hour. That's hourly because I can't control the result or how much time that takes. Documents are on a fixed fee basis. Special needs trusts are $1,750. Okay?
No matter how much information?
It doesn't matter.
Okay.
It doesn't matter. I do them every day, day in, day out.
It's tax
okay?
deductible too.
Yeah, they're all tax deductible expenses. So there's no such thing in my world as a simple will. They're all tax efficient wills. There's no such thing as anything like that. So that's the way it goes. That being said, I know when you come to me, I know what everybody has. I'm a tax lawyer. You tell me all your financial information. And if it is a hardship or somebody can't afford me, I will figure out a way to work with you if you are motivated. Yes.
So, many years back, an attorney told me to have a shared guardianship with my son's biological father. So he is on guardianship. So his life is a mess. He's a mess. Not my husband.
Not the guy sitting right here.
Yeah.
She's called me worse.
So just because someone is on the guardianship, they can't get into your trust. They can't get into Paul's trust.
No, it's two different things.
Okay, so there's no way just because he, like if I died first, I know, oh, God forbid, just God forbid, I have to live for a really long time. But anyway, but if that would happen, at least financially, I can make sure that the person that I trust would be giving things to Paul.
Correct.
And that he would not have any way to touch any money.
He can't touch it, but I will tell you what he can do on behalf of him, okay? Because I'm not going to sugarcoat it. He can make your trustee's life miserable by forcing an audit. You can audit it because he's his guardian. So he can force a financial audit all the time. Now, that is worse than it sounds in this day and age because you can automate so many things and show payments and things like that. But that, he will have basically the right to do that as the guardian. So you have to make really, really sure that whoever your trustee is, and I assume it would be you know, has those back supports and everything. So if I was doing it for you, I would give you the right to appoint a co-trustee. You might want the backbench of a corporate fiduciary sitting behind you, because every time you got that audit, you would pick up the phone and say, just handle it, because you don't have the energy to deal with that all the time. It's too much. The opportunity cost of that is just too high, you know, so you have to build in those things into the document. He can't touch the money, he'll never touch the money, he can't control the money, but he can be an aggravation.
Yeah, one thing you said on the grandparents, other family members are a great resource to tap into for this type of planning to get them involved. You know, if grandparents want to help out, there's a great way for them to do it if they want to, because remember, your parents leave money to you, it's going to be taxed. You then leave it to your kids again, it's going to be taxed. So, and if a parent happens to live in New Jersey, one of the most expensive states to die in, that is definitely a cause for some planning conversation to be had, if they are open to it. You know, if they're going to be leaving money to you anyway, or if they're gifting to you already, if they're open to learn about other ways that they can do it for your child with special needs and also incorporate other grandchildren, they're a great resource to tap into. And even if they don't really do anything outright, you still need to tell them that they have to do things. They need to put a specific sentence in their wills that will take into consideration what you've done with your special needs trust. Because grandparents are great, but they can also cause a lot of issues if they don't do things the right way.
Just to go off of that, when we did ours with you, we asked, she did a letter for us so that we can send, and I'm divorced, so to send it to my ex-in-laws, and there's a tax ID, so it's not like, oh sure, Mariah set up this trust, and why don't I put money in it? And it has its tax ID, it's its own entity. Here grandma, here great grandma, here aunts and uncles. If you are going to ever leave anything to these children, especially this one, please do it in this way. And it was well received. It wasn't us trying
Because
to.
the letter doesn't go directed to them, the letter goes to them, and we just do it on nice letterhead and disperse it. So it doesn't look like you're looking for a handout, it's just like FYI, because well-meaning intentions, people make mistakes, that's all, just so they can take it to their lawyers and make sure it's done the right way.
Randy,
Yes.
as far as, I know we didn't touch on this today.
In a relationship, it might make life simpler, although not cost effective to set up. Right reason why we shouldn't each individually approach you.
No, as long as you both know it.
Yeah, I mean, it seems to me
Yep.
feasible, don't it?
Yeah.